After tens of millions of dollars in verdict, including a $63 million verdict, and writing the book on TBI litigation, I can tell you, we talked to 250 lawyers last year. Most lawyers in TBI cases are working on the wrong problem. They're working on one thing that is work up the case, which is the same approach they've taken on every case they've ever worked on. That's a mistake. There are 4 different ways to work up a TBI case, and they range in value. I want to explain the framework, and let's get into it. What makes a TBI case more valuable? As a lawyer, people inherently realize there's significant value to TBI cases, but as I just got off the phone with a lawyer 20 minutes ago, she kept asking similar questions about her valuation and what I would do to increase the valuation. And for those of you who don't know me, I'm Taylor Ernst, 2024 California Lawyer Attorney of the Year, according to the Daily Journal, $63 million verdict. I wrote a book on TBI litigation. I only share that so that you know I've lived this. The amount of notes that I've taken over the years and have been put together to put in the book is significant, but that's not what I want to talk about today. What I want to talk about is when she found us and said, hey, I've got this big TBI case, I want you to take a look at it, and was asking us a number of questions, she kept coming back to the same thing, which is what makes a TBI case more valuable? And then she was talking about how she was working up the cases. And I think it's something that all lawyers do is we work on cases and we work on cases and we work on cases. And I realize there is a problem that lawyers don't talk about enough. There's a fundamental misunderstanding by lawyers when they're looking at the same way to work up the case over and over again. And they will see the same medical records, they'll see the same diagnosis, they'll see the same experts, and they work the case up the exact same way no matter what the case is. And that doesn't work in TBI cases. And the reason it doesn't work in TBI cases is a fundamental approach blindness. And what the blindness is people will assume if a case is between 0 and 1 million, it should be worked up the way if the case is worth between 1 and 3 million, which is the same if it's 3 to 10 million, which is the same if it's 10 million plus. And they are all different approaches in each different category. And the reason there are different approaches in different categories is the big problem that you use to make the case worth more comes down to 2 things. One is, are you trying to make the case worth more in settlement, or are you trying to make the case worth more at trial? Because they are wildly 2 different approaches. And I'll just talk about both of them. To make the case worth more in settlement, you need to understand what is the big thing. I call it the governing disagreement. Like, what is the disagreement that you and the defense lawyers who fundamentally disagree with you see differently? And then what evidence do you have to change that governing disagreement? Because if you don't have evidence to change what the defense lawyers think, you're not doing anything. You could spend 80 hours a week working on your case, but if all the effort is not working on the government disagreement for what the defense lawyers think of your case, it's not going to change anything. They're going to write the same report they wrote before because they're going to say there's no material facts that change the outcome and rating that we see as risk on this. And so you haven't done any work. It doesn't matter how many hours you spend, you haven't done anything. And so in talking about settlement, it's a different approach than talking about trial. I'm going to talk about it from a settlement point of view because the trial is, frankly, a whole other video, a whole different tactics, and it's an entirely different approach about gather, focus, reveal. I talk about it in the book. This is for settlement. If the case is worth between 0 and $1 million, the real governing issue comes down to a credibility problem almost 100% of the time. It sounds like this. In the defense neuropsych report, it'll say not good enough effort. If the defense expert is somebody from way before, it will be malingering. It will be they didn't put forth good effort. It's somatoform disorder. This is an atypical presentation of a TBI. There'll be words like that in there. And basically what they're saying is, we don't believe your client is that hurt. Generally, it will pair with they're still working. It will pair with they've had some impairment, but people around them haven't noticed as much. It's a credibility problem fundamentally. And credibility problem is the umbrella that covers all of it. When you have a credibility issue, you don't need more medical evidence. You need something that makes the defense lawyer and jury understand and believe the injury's real. That's it. And I give this example all the time, so you may have heard it before if you've seen some of my other stuff. But like, if I have a client that has a memory problem and the neuropsych says memory problem and there's correlation on an MRI, and the defense lawyer is like, they've got memory issues, but lots of TBI clients have memory issues. That's one case. Now, here's a different case. The client has a memory problem. And you say, well, how do you know he's got a memory problem? And you can tell this to the defense lawyer, or you get it out in depo, or you do a declaration, or there's 50 different tactics to get the information to the defense. But you need to get this information to the defense first. Before you can get the information to the defense, is you need to understand the information. There's a client that had memory issues, and she would have her kids come to the house, and she'd always be like, oh, I want to serve my kids ice cream. And so she would tell her son, hey, I'm going to go around the store to get ice cream. The son would be like, I don't think you should be driving. And she's like, no, it's fine. It's only a couple blocks. She gets back and he's like, hey, Mom, we're back. And she's like, oh, yeah. And he's like, the ice cream, I must have left it in the car. He goes out to the car, opens the front door of the car and looks in to get the ice cream. And there's a sticky note on the steering wheel that says, remember to turn off the car. You hear a story like that, and fundamentally, it's this cascade of things. Oh my God, crazy memory problems. She shouldn't be driving. She probably shouldn't live alone. All that happens with a single story. And it isn't medical evidence that moves the needle. It's something that is so true that the defense can't not believe it, because it's just so awful and all-encompassing and real that they hear that story, and credibility is no longer a problem after you hear that story. It's just not. I was in trial one time and we had a credibility problem where the defense for 3/4 of the trial kept saying, she's in it for the money, she's in it for the money, she's in it for the money, because she's still working and filing a lawsuit. She's in it for the money. And we put one witness on the stand, and we did a tactic that internally our office calls it story breaking. And what we did is we knew that the defense was going to say, hey, she's in it for the money. So what'd we do? Put the witness on the stand and said, hey, did you know the plaintiff? Yeah. The defense has been saying she's in it for the money. What do you think about that? Oh, that's absolutely false. How do you know that? Well, she's got 4 kids, and I have been the one telling her she should get spousal support. And I've been telling her that for 7.5 years, that you need to get spousal support. And you know what she told me every time? I don't need any help from my ex-husband. I can do it myself. And so in this case, what do you think? Like, I know she's not in it for the money because she fundamentally has never asked for a single penny from her ex-husband, even though he owes it to her. And you hear a story like that, and then the defense stands up and says, she's in it for the money. No, they don't. Funny enough, the defense never made that argument again because they heard such truth in credibility that the credibility threshold was utterly destroyed. And so it was no longer a credibility problem. Like, the only reason you get up in closing, you say, this is the first time this plaintiff has ever asked for help, and we need it from you, jury. This is the only time she's going to be able to get money from this case, is you deciding what to do. And all of a sudden, that credibility problem is no longer a credibility problem. And that's the $0 to $1 million range. The next level is $1 to $3 million. And that generally deals with scaling damages, and it's vocational rehabilitation. So loss of earning capacity, lost wages, and medicals. Past and future medicals. Generally for TBI cases, the past medicals, it depends if there's a skull fracture or intracranial neurosurgical options that are needed. That's one level of case. Post-acute, if they're in a coma, it's one level of case. But then also a lot of times it's the significant future care that ends up being the bigger number. And so those two numbers, generally you need not one, generally you need one or the other if you're going to be in the 1 to 3 million range. Generally, if you have both, it puts you in the 3 to 10 million range. Usually. There's exceptions. So let me give you an example of the 1 to 3 range of scaling. Is we had a client that we got a verdict for a number of years ago, mid-7-figure verdict. I only say that to give you an understanding of how this actually worked. And what it really was the client was still working. So we didn't put on a loss of earning capacity claim. And frankly, the medical futures that we put forth were a couple $1 million, but then we asked for non-economic damages on top of that. But the couple $1 million were legit. They were very real. And we had the defense expert basically have to get on the stand and testify that if certain scores were real, he'd need inpatient care for the rest of his life. And all of a sudden you get that kind of testimony. The jury gets the picture really quick that even if the defense says inpatient for the rest of their life, it's a pretty significant future medical plan. That gets you that scaling number. The next one is that $3 to $10 million range, which that really comes on what I like to view as trial reputation. And the trial reputation comes from basically being in trial enough and having enough bad things happen to you during trial that you're like, well, I'm not going to make that mistake again. And it preloads a bunch of the arguments that you want to make about damages in a way that they understand how to scale the TBI damages to the jury. So the generally the thing from 3 to 10 million is a trial reputation. And the reason that matters is you will get situations where the value of the case is brought out by some of they're tiny things, but there's 1,000 of the tiny things that you need to do right to get the value where it needs to be. But to give you an example, we had a client that had a TBI and they disputed it, and we're trying to figure out, we had the numbers for the scale part of it. So we're out of the 1 to 3 range and we were into the 3 to 10 range. It's so weird how the ranges work. But what ends up happening is the defense took a position where they basically are like, well, yes, he's got a TBI. Yes, he's got some issues from it, but we're only going to offer $1.5 million. We're only going to offer $1.75 million. That's it. Trial authority. We're going to trial if you don't take this number. And what the real unlock is figuring out what they're hung up on and say, just ask them, like, why do we see this case so differently? I see it as 9. You see it as 1.5, 1.75. Why? Tell me why you think that. And because a lot of the time what ends up happening is the defense experts, especially if the defense counsel hasn't tried a lot of TBI cases, the only person telling them about what they think of your client is their neurologist, who does 95% work for the defense, and the neuropsych, who does 90% for the defense. And of course they're going to say, hey, there's no significant TBI. I have clients that have literally had skull fractures, brain bleeds, and I have one right now, where the defense report says there was no concussion. If there was a concussion, it was a mild concussion. If there was more than a mild concussion and there is cognitive impairment, it should have resolved after 6 to 8 weeks. They say that because they want to basically get more work from the defense. And the reason they do 95% work for the defense is because they say that over and over again. And so if the lawyer isn't very educated and doesn't see the risk, and the defense says your client's faking it because they want more work, that's the world they're operating in. They don't know the story of a client who built his own house and then we had this happen at trial, built his own house. Literally, we're in the client's house because we're going to the client's house ahead of time. And we're looking at these vaulted ceilings and we're like, wow, look at this house. And it was in an area where there's all these houses, but we looked at the vaulted ceilings and we're looking around and being like, this is amazing. And he's like, oh yeah, I built that. And we're like, what do you mean? He's like, oh yeah, I built my house. What do you mean? Oh, other than pour the foundation, I pounded nails to build my entire house. And we're looking at each other going, oh my God, this is insane. And then an hour later, we're sitting at the dinner table and looking through some stuff. And we're like, what's that math book? You don't have kids. He's like, oh, it's my grandkid's math book. And we're like, why isn't it at the grandkid's house? Oh, it's a 2nd grade math book because I want to be able to teach my kid the math. And after the brain injury, I can't do the math anymore. Like, listen to that story. He built vaulted ceilings and now is at 2nd math grade level homework that he has to do the work ahead of time so he can help his grandkid do the math. And that's the kind of story that you immediately hear and you go, oh my God, that's a significant brain injury. But you don't have that information in the medical records. You get that information by working the case up, knowing where the problem is that you need to solve. And so when the defense says, yeah, hey, we don't think it's that significant of a cognitive impairment, you literally hand them the math book and they're like, what's this? And then you tell that story. And they're like, oh, that's going to land with a jury. We need to put more money on it. So the next one is the 10 million plus. And 10 million plus is in its category on its own. And frankly, it has to do with a lot of belief in your trial skills, your client, and how significant they are hurt. Because most lawyers across the entire country, if a client, and it's one of your more significant cases in the office, and if the defense came to you right now and said, hey, I'll give you $9 million to settle that case, most law firms will say yes. The problem is you don't get a $10 million settlement when you say yes to 9. It's so easy to say, but it's so hard to do. And it's the reason that you need to build the skill set, build the belief, build the evidence that when the defense says, hey, 9, final answer, trial authority, we're never offering you a penny more than that. You look at them dead in the eye and go, okay, well, guess we're going on trial. And that is the unlock for how you get 10 plus, at least in terms of settlement. Trial, again, like I said, different thing. So it really comes down to that chart is 0 to 1 is credibility, 1 to 3 is scaling, 3 to 10 is basically trial reputation and earning all the problems of those 1,000 things you need to fix before a trial. And 10 plus, it's that self-belief in terms of settlement values of like what you are willing to say no to because the standard's high enough that you know you can prove it. Or at least have a reasonable expectation you're going to do better at it ethically for your client to be able to say no. And the real unlock there is if you don't have a trial reputation and you consistently settle cases, the defense knows you're going to settle the case. And so you have to go earn the trial reputation where the defense literally writes the letter that I know they've written on our firm because the senior VP adjusters called me. I had a case that went sideways on him, and the senior claims guy that was like so high up, he was calling me from across the country. He said, he literally got on the phone with me and said, what will it take to settle this case? Which I couldn't believe came out of his mouth. And then I was like, did I say a number too low? But that's a whole other story for another time. But like when they call and say, yeah, we know you guys are the real deal. We know we need to pay trial value. What's it going to take to settle this case? I know that reputation has been built over time. And so that reputation comes from doing it over and over again enough that the defense values it differently than they value it against most other law firms. So does the defense fear going to trial against you and go, hey, those guys are the real deal. They're going to really swing it at you. Be careful. You need that conversation going on within the adjusters. So use the chart and figure out where your problem is, and then don't work up the case. Because if you work up the case and you work up $1 million case the same way as you work up a $1 to $3 million case, the same way you work up a $3 to $10 million case, and the way you work up a $10 million case plus, don't do that. You're solving different problems at different levels. And if you think, oh, it's a $10 million case and therefore I'll just spend more on experts and do more art, you're missing going after the fundamental disagreement that you and the lawyers have that'll make your case more valuable. I'm Taylor Ernst. See you next time on TBI Lawyer Secrets.